structure of the webinar is going to be that we'll do about 30 to 40 minutes maximum in I hope, a discursive format, discussing issues that we have all come across in our daily practice lives in relation to tracing and remedies of practical considerations of crypto assets. This one follows on from one that we did, I think, a couple of weeks ago, perhaps a bit more, which was more theoretical, which some of you may well have attended. This is the practical side. Can I also invite you that to see that any questions are posed to us through the Q&A box, because what we're endeavouring to do is to spend about 20-25 minutes on questions to try and see if we can assist with particular circumstances that you as practitioners may or may not have met. And that's what we're seeking to do, because that, we hope, gives you all the most out of these seminars and webinars. So, as I say, Dean Armstrong QC, I am Joint Head of Chambers of the 36 Group. Part of that group is the 36 Commercial team, and part of that team is the 36 Cyber team, of which I'm the head. I'm a published author on blockchain and cryptocurrency. I'm a published author on cyber litigation, published author on cybersecurity law and practice. There's a cyber risk and insurance book on its way imminently, I might say. I, along with my colleagues, pretty much specialize in this field on a day-to-day basis. I'm delighted to be joined by Celso de Azevedo, who is a barrister in 36 Commercial. He's also an attorney from New York, and also a fellow of the Chartered Institute of Arbitrators. He has over 20 years experience in insurance, cybersecurity, data breach, cryptocurrency, fraud, asset tracing, and regulatory investigations. He is also a published author, and he is the author of the Sweden Macro publication, Cyber Risks, Insurance, Law and Practice. Equally delighted to welcome Kerry Davis, who's also a barrister at 36 Commercial and also an attorney and counsellor of law in New York, USA. She specialises in cyber, data and technology matters and commercial crime and regulation. She is also co-author of the book that I've mentioned with me, of Cyber Litigation, The Legal Principles, published last year by Bloomsbury. Mark Samuels, also a barrister at 36 Commercial. Mark's practice focuses on cyber and commercial law and matrimonial finance. And Mark is also a published author of Commercial Contracts for UK Companies, Formation to Exit, published this year by Bloomsbury Professional. So thank you. Those are the introductions. And what I'm going to do now is I'm going to hand over to Mark and to Kerry for the first section, which is going to be cyber security trends.
Okay, thank you, Dean. Well, 2020 moving into 2021 has been certainly eventful in terms of cybersecurity. Many on today's webinar will have seen the Acronis cyber threats report of last year, the contents of which were hinted at by its subtitle, The Year of Extortion. The report found that in 2020, an astonishing 31% of global companies were attacked by cyber criminals at least once a day. And there's another stat for 2020, more than 1,000 companies had their data leaked following ransomware attacks. In terms of cybersecurity trends for this year, the report anticipates that attacks are going to, in particular, increase in relation to remote working operation, and there'll be more attacks on MSPs, managed service providers, as well as small businesses. The report also anticipates that attackers are going to use more automation, and there'll be a rise in the number of malware samples. Unsurprisingly, the report identifies that ransomware is still the #1 threat when it comes to cybersecurity. And according to an associated report published by Coalition, ransomware cases have accounted for 41% of cyber insurance claims filed in the first half of 2020. In terms of other headline news, we've also very recently seen the high-profile case of Colonial Pipeline, the ransomware attack in the USA. Colonial Pipeline obviously delivers roughly 45% of fuel consumed on the East Coast. That attack resulted in the company having to take the entire pipeline system offline to deal with the threat. And in terms of more recent headlines, Joseph Blount, Colonial Pipeline's CEO, confirmed last week that the company paid the hackers, DarkSide, $4.4 million to regain access. Similarly, we're also seeing increased associated activity in the US government. In Washington, the Justice Department has established a new task force to deal with the proliferation of ransomware attacks, while last week the North Carolina House of Representatives passed legislation prohibiting state and local agencies from paying ransomware demands or even communicating with criminal perpetrators attempting to attack the networks. In Washington, they described 2020 as being, and the quote is, by any measure, the worst year ever when it comes to ransomware and related extortion events. In line with this, we're also seeing a rise of crypto asset fraud in the context of ICOs, crypto asset investment schemes, and also email spoofing. So all of this leads us today to our core question for this webinar. What do you do when you are the victim of a ransomware attack or crypto asset fraud? How do you get your crypto assets back? So on that introductory note, I'm now going to hand over to Kerry, who's going to kick us off with some practical points for consideration.
Thanks, Mark. So you have a ransomware demand or you find you're a victim of fraud. The first thing you need to consider is whether or not you have any potential criminal liability under terrorist financing regulations or sanctions legislation. We've spoken about that in detail in other webinars. So have a look on the 36 Commercial YouTube channel or on our website or Spotify for our podcasts to hear more about that. But specifically in relation to ransomware attacks, if a company has good offline backup practices, then it should not need to pay a ransomware demand in order to gain access or regain access rather to its system and data. Simply restore from the backups. So good offline backup practices negate the need to pay a ransomware attack and therefore removes the risk of criminal liability. And therefore, in those circumstances, the only potential question of liability may just be civil and regulatory. However, coming back to what Mark said about Colonial Pipeline, you heard that they paid the ransom of nearly 5 million, and that was despite having backups. One of the reasons that one can assume that this happened is that restoring from backups takes time and a decryption tool might be quicker. Plus, there may be other reasons that you want to pay a ransom. For example, concerns about the publication of sensitive or confidential data, etc. But in the Colonial Pipeline case, the decryption tool was so slow that Colonial Pipeline continued to use their own backups to help restore the system. So there's no guarantee that if you pay a ransomware demand, that the decryption tool that you're going to get is going to work or help. Therefore, one of the key things that you and your client should undertake is good data management processes and systems, because that is going to help if you ever face a ransomware attack. And so with those practical points out of the way, we will go on to what happens when you have paid a ransomware demand or you find you're the victim of fraud with crypto asset tracing and investigations. So Dean, you find that you've paid a ransomware demand or discovered that you're a victim of fraud. What do you do next?
Well, the first step is asset recovery, and in that asset recovery is tracing the funds. The second, and we'll come on to the second step later, that's securing the asset. But let's talk first of all about that first step, which is tracing the funds. Very important that anyone listening to this who doesn't already know, cryptocurrency is traceable. Absolutely, it's traceable. So it's vital that people are aware of that. Let's take an example. Let's take a very local example. Lots of people at the moment trading in Bitcoin. Bitcoin transactions appear on the face of the public blockchain. Now, I always at this point stop to explain very briefly that there is a public blockchain whereby with certain proper keys, anyone can see the transactions. And there's also a private blockchain, which is permissioned and you need certain access requirements in order to be able to see the data. But we're talking here about Bitcoin. So first and foremost, Bitcoin is traceable because it's on the public blockchain. And there are also, and I work with a number of them, a number of really excellent specialist companies and groups of people who specialize in the tracing of cryptocurrency. The issue about cryptocurrency tracing is usually becomes tricky when it reaches the exchange, because then there's always an element of those who have, particularly if it's a ransomware case, wanting to get the crypto out of crypto ironically enough, because it is so traceable, and into fiat, which is not traceable. And that's a very interesting, perhaps topic for another day, but there's a good example of crypto being more traceable than fiat. So once it's left and gone into fiat, then it's very difficult, almost impossible to trace. That is when you seek to make disclosure orders against the exchange and try and take steps to secure the assets, and we'll discuss those later. Before I hand back to Kerry, however, it's important that I say a couple of things, and just because, and we will be talking a lot in this webinar about interim relief, but just because crypto has left and gone into fiat and is therefore prima facie difficult to trace, it's important that you don't admit defeat, or your client doesn't admit defeat. Let's not forget, and I'm certainly involved in several at the moment, that there are traditional final remedies that you can get your crypto back. Crypto is property in the way that anything else is. And so the normal rules apply in terms of abilities to sue and to gain relief in that context. So there may be some more discussion about that later, but it's important that people don't think that crypto is only about interim relief, because crypto is an asset, crypto is property, and therefore it is recoverable and actionable, if I can use that expression, in the same way as conventional other property is. So Kerry, if I can hand back to you.
Thanks, Dean. So you talked about Bitcoin, and we see that a lot in the cases, that is what people are asked to pay ransoms in, and that's how people are defrauded. But what if the cryptocurrency can't be traced? I'm specifically thinking, for example, of Monero, where its privacy is different from other coins, because it uses 3 different privacy technologies. So it uses ring signatures, ring confidential transactions, and stealth addresses, all of which hide the sender, amount, and receiver in the transaction, which means that all transactions on the network are private as a matter of course, and there's no way to accidentally send a transparent transaction. In those cases, what do you do if you've had to pay a ransom in Monero, or you found out you've been defrauded in Monero?
Well, it's 2 points, because, and it's really important, and this is the way I look at things when I'm advising. Is there an interim relief available for a crypto asset? Particularly, as I say, has it reached an exchange? Is it still available in that sense? But just because it is not traceable, and you're right, Monero isn't traceable, doesn't mean to say that you lose all of the usual rights that you would deploy to get back property which has been improperly dissipated effectively. And that's really crucial to remember. But it also is important that we stress that Monero is a special case in this particular context, or one of the few special cases. And so anyone who is seeking to have advice and is advising a client, if they see the word Monero, if they see the currency Monero, crypto Monero, then it's very important that straight away, if they're advising them in the first instance, you give them the health warning, which is that it's not traceable and therefore susceptible to interim relief. Doesn't mean to say, however, that you burn all your bridges if you're dealing in Monero.
Thanks, Dean. That's really interesting and really helpful. This actually comes back to something you mentioned earlier about actually having final relief available. So, for example, if you find that you are the victim of a long-running fraud, I'm specifically thinking of cases, for example, like OneCoin, although that's on a massively different scale from the ones that we come across in everyday practice. Interim remedies may not be available in those cases. The assets have been dissipated, they've been changed into fiat. So what approach do you take then in terms of seeking final remedies?
Well, I happen to currently be advising on 4 cases where final remedies are being pursued. That's either because it's a combination of assets have not been able to be traced, or whereby assets have literally just been have left an exchange. And as I say, the most important thing to remember here is that all of your usual remedies are available to you. One thing to say, and what I'm about to say is not in any way meant to be critical of traditional law enforcement in the UK. I get a number of people who come to me and say, this has happened and I want them prosecuted by the police. Sadly, for a number of reasons, certainly resource, and second of all, potentially a lack of people to actually deploy investigation into these sometimes very complex matters, it's very difficult for the police to effectively act quickly enough in these situations. And we, as we will see later, speed is the key in many of them. And so, without in any way being disrespectful to police and law enforcement generally, it is very difficult to rely upon the police to get dissipated crypto assets back. However, as I say, all of your usual remedies are available to you. Interesting, one of the cases that I'm doing at the moment, fascinating case, where a large amount of Bitcoin has been dissipated. We, as a result of our inquiries, again using one of the specialist companies that I mentioned earlier, have uncovered, in fact, to those line of duty watchers, an OCG involved in crypto asset defrauded in this situation. So, but again, it's back to the usual stuff. It's back to what would you ordinarily do as a commercial litigator to get these assets back. So, as I say, just because it's crypto doesn't mean to say that you can't do anything about it. Far from it, in fact. So we're now going to move on to our next section, which is going to be not about final relief that I was talking about there, but it's going to be about injunctions, causes of action, disclosure, and cross-examination. So I'm going to leave Mark to start that section.
Well, Dean, as you've said, we can see from the case law that interim relief is really proving to be the most important step when it comes to asset recovery following a ransomware attack or a fraudulent transfer. And the reason for this is that a court order, if obtained promptly, which is key, can of course secure crypto assets and stop further dissipation, by which we mean preventing the party from moving, hiding, or otherwise unjustifiably dissipating the assets so as to defeat an eventual judgment. So my first question on this topic, which I'm going to put to Celso, is what are the forms of interim relief that you can apply for in order to secure crypto assets and stop further dissipation?
Yes, Mark. The main interim relief is, because it's the easiest one to obtain, is a proprietary injunction or proprietary order. And the reason why it is the easiest one to obtain is if you compare with a freezing injunction, you do not need to prove the risk of dissipation to obtain a proprietary injunction. All you need to show is that there is an underlying proprietary or tracing claim against the crypto assets. And in fraud cases, the balance of convenience test, which is one of the tests to obtain a proprietary injunction, is usually granted on the basis that there is no evidence at the time that you make the interim application ex parte on emergency basis that the wrongdoer will satisfy a monetary judgment. And because of that, as a generalization, a proprietary order is the easiest one to obtain.
Well, so that being the case, I suppose I'm slightly testing that. Are proprietary injunctions enough to protect people's interests, or should they also be looking to other forms of interim relief? I'm particularly contemplating a freezing order or a worldwide freeze. What would you say to that?
Well, the freezing order is not an order against the property itself, against the crypto asset. It's a personal order, personally against the respondent, the defendant. And it prevents the respondent from moving, hiding, or unjustifiably dissipating the frozen assets so as to defeat any eventual judgment against him. It differs from the proprietary order because the freezing order attaches to the party personally, but there is a higher threshold for the freezing order because the applicant or the claimant has to show a risk of dissipation of the assets, which is not required in proprietary injunctions. And in order to be fully protected, based on the case law, an example is the Iron Science case. If the claimant can show a risk of dissipation of the assets, he should go for all of them. Get the proprietary injunction, the worldwide freezing injunction, which would then, prevent the dealings of assets worldwide. although this point was not decided in AA and persons unknown, as the application for freeze injunction was adjourned in AA and persons unknown, there is case law showing that the risk of dissipation may be shown in freezing injunctions by the nature of the underlying claim, so fraud or deceit, the defendant's conduct involving the use of aliases or apparently using false documents, and the nature of the defendant. So if the company, the exchange, is not registered, or it is registered but not registered with the regulator, or if there is a regulator's warning against that exchange, all of that is taken into account to show the risk of dissipation so that the applicant can get a freezing injunction. But Mark, let me ask you a question to test you now. The test for freezing injunction or worldwide freezing injunction requires the existence of assets belonging to the defendant. However, where the defendant is a person unknown or persons unknown, the claimant cannot satisfy that element of the test. So how are the courts approaching this issue?
Well, Celso, it's an interesting question. And in fact, you've half led me to the answer already, because here we're looking at the Ion Science case, which it's interesting because the judgment acknowledges that this sort of case is effectively quite unlike an ordinary freezing order situation. The court found in that case that the fact that there weren't assets which could be caught by the order was not a bar to granting a worldwide freeze, as it was a typical feature of a case against persons unknown. There was, however, and you've already mentioned it, in that case, a real risk that the assets could be dissipated, and the court also recognised the persons unknown's use of aliases and false documents, and also the company that you referred to, Neo Capital, had not been registered. But for our purposes, it is an interesting authority in that it potentially offers a blueprint for not needing to show that the defendant has assets in a strictly persons unknown crypto case.
Okay, so let's turn to the type of relief and any distinction in the case law. The case law to date seems to show a difference in treatment between the type of release that will be granted depending on whether the respondents are persons unknown or named individuals. For example, in the case of Robson's and persons unknown, or AA and persons unknown, in Ion Science and others, and persons unknown, where they have proprietary injunctions granted, versus Stone and Murray, where the original proprietary injunction was discharged in favor of a personal remedy. What is the difference here?
I think the answer lies in the practical point that after the applicant has established that there's a serious issue to be tried in a proprietary injunction application, as you've said, the court then considers whether the balance of convenience lies in granting the relief. And the balance of convenience involves consideration of the efficacy of damages as an adequate remedy, the adequacy of cross undertakings as to damages, and also the overall balance of convenience, which includes the merits of the proposed claim. So in a persons unknown case, there is likely to not be any evidence that the individuals in question will be able to satisfy a money judgment. And this means theoretically that a proprietary injunction is likely to be the only realistic mechanism for recovering loss in those circumstances. By contrast, in the case of an unknown defendant, a named defendant, practically speaking, although there may not be evidence of assets when applying for the injunction, there may be on the return date. And so there may also be evidence as to whether or not the named respondents will be able to satisfy a money judgment. So this makes a proprietary injunction in those cases not a foregone conclusion. Kerry, I think I'm handing over to you there.
Yes, you are. You're handing over to me. I can ask Celso a question following on from what you said, actually, about sort of named and unnamed defendants. So in the case of Choma and Murray, named defendant, a proprietary injunction was granted initially, and then that was discharged on the return date. So Celso, are damages actually an adequate remedy in a crypto asset case?
Well, the answer is it depends. Most of the case law shows that at the initial stages, so at the initial stage where you make the application ex parte on an emergency basis and you don't know exactly what is happening, even if it is a named defendant, as in the case of Tom and Murray, the courts are more likely to accept that damages, or because it's not known, not easy to prove, that damages are not an adequate remedy and grant the injunction. But then in Tom and Murray, after the injunction was granted ex parte, on the return date where the court would consider whether to maintain the injunction on a permanent basis or not, the court discharged the previous proprietary injunction, freezing the Bitcoin accounts, holding that although the claim against the defendant was a proprietary tracing claim against the Bitcoin, the claimant was ultimately seeking the value of the Bitcoin held by the defendant. And for this reason, the claim was capable of being satisfied in monetary terms, in damages, pointing to the discontinuation of the proprietary injunction. And the court distinguished the case, Tom and Murray, against the decision in AA and persons unknown, on the basis that in Tom and Murray, the defendant was identified, and crucially in Tom and Murray, that it was shown that the defendant had significant unencumbered assets. So the court was not persuaded by the argument that there was a risk that the defendant could become insolvent. The court said, well, this risk also exists for the defendant, that the claimant may go insolvent in relation to the crossing undertaking in damages that was given by the claimant. So that is the situation, the position at the moment. But Mark, if you can deal with the next question, please.
Yes, and I'm going to be throwing this your way, Kerry. It's slightly slide aside, but it's linked. Ransomware attacks, as we know, sometimes involve the threat to release or publish data online, and depending on the data, there can be associated civil liability issues, such as GDPR claims, possible ICO regulatory action, etc. So, Kerry, on that topic, can any form of relief be sought in respect of the published data? And I suppose in connection with that, do you think that the court might look favourably on an application for a website blocking injunction, for example?
Yeah, so as with Celso's answer, it depends. I think the court would be willing to extend the jurisdiction of a website blocking injunction to cases where data is published online following a ransomware attack. But it's fundamentally going to come down to the test for a website blocking injunction, which requires that the published data needs to be infringing the claimant's rights. If the data that has been taken as part of a ransomware attack is the company's own confidential data, sensitive data, and that's published, I don't see any problem with the company making the application for website blocking injunction. If it is data of their customers, however, or their employees, might be a harder hurdle to satisfy the court that their rights, the company's rights, are being infringed in those circumstances. So again, it depends on the circumstances of the case that you've got in front of you. But a sensible attacker, I say sensible attacker, is never going to get rid of the data that they take from you. And so if your data is taken as part of a ransomware attack, you effectively have to be forever vigilant to see whether or not it's published, because the internet doesn't forget things. It will be there somewhere. And even if it's taken down, it may come back. So you're going to have this added burden and liability if your data is potentially taken as part of a ransomware attack. Mark, I have a question for you in a minute about causes of action, but before I get to that, I'm just going to remind everyone watching that we are answering questions that we have come across in practice. So any questions that you have come across in practice that you'd like us to answer or address, or any thoughts on, if you put them in the question and answer session when we get to the end of our questions, we will happily address those.
Thank you. Kerry, before you ask Mark the next question, I'm going to butt in for a second, just to reiterate the point that you make, because we get very lonely if we're not answering questions from you guys. The last one I did, I think we were up to 17 or 20, so you've got some making up to do at the moment for us to be put on the spot. The other thing which I should have mentioned, and I hope that people are not writing too hard, because candidly there is no point doing that. What we always do, those of you who have listened to these webinars before will know, but we always send out to each of the people who've signed up to be attendees a digest which deals with the significant cases that we've talked about, and courtesy of Mark and Kerry and Celso particularly, a little discussion about what they mean. So don't worry if you are sitting there thinking there's a slew of cases coming your way and you're not quite understanding which case we're moving on to next. It is all in the digest for you. We prefer, if we may, that you listen to get a feel for the general overview of the subject. And as I say, the digest will follow. So my apologies for butting in on that, but please start those questions for us. We're looking forward to them.
Not at all. So just a little bit of sort of background. So in order to obtain a proprietary injunction, you need to show, amongst other things, that there is a serious issue to be tried. And similarly, for a freezing order or worldwide freezing order, must establish a good arguable case. Mark, in light of these tests, what causes of action can be brought or intimated in applications for interim injunctions where people are the victim of a ransomware attack or a fraud?
Well, it's a good question. And already today, our audience has heard the one-liner that it very much depends on the circumstances of the case. That is also true here. In the context of a ransomware attack, you could be thinking about, we've discussed it already, a proprietary claim, which is where the claimant claims to own a specific asset or sum, i.e. in contrast to a claim for damages, and it usually arises where property has been stolen or wrongfully transferred away. And it can also feature in the context of cases of bribery, undue influence, effectively unconscionable conduct, etc. You could also, depending on the circumstances, think about pleading unlawful means conspiracy. This arises where there is an agreement or combination between two or more persons. Note that a person for these purposes can be a body corporate, to injure the claimant, and where concerted action has been taken by those persons pursuant to the agreement, and where that action is unlawful, and the effect of that has to result in loss to the claimant as a result of those acts. So those are the elements for unlawful means conspiracy. In the case of fraud, you could also consider the tort of deceit, which is a tort arising from a false statement of fact made by one person, knowingly or recklessly, with the intent that it would be acted upon by another, i.e. the victim, and that other suffers loss as a result. And again, in the context of fraud, you could again think about unlawful means conspiracy and an equitable proprietary claim. You could also think about whether a constructive trust has been established over the crypto assets in favor of the claimant. And similarly, you could ask yourself whether a quis close trust has been created, as in some circumstances, money will be paid across for a specific purpose which has failed, and in which case that money is arguably held on trust for the claimant/victim. It's also worth reflecting on what we discussed earlier about how different remedies may be appropriate depending on whether the anticipated defendants are named or become known, in which case it could be the case that a proprietary claim may not be the most appropriate cause of action, in contrast to, say, a personal remedy. And that goes back to the ion science point that we discussed earlier. However, now it's my turn again for a question, one that I have. We've discussed injunctions to stop the dissipation of assets, both in terms of crypto assets themselves and also the assets of the perpetrators that we would be using to try and satisfy a judgment. But Celso, in a person's unknown case, how do you go about identifying the perpetrators of, say, a ransomware attack or a cyber attack in the sorts of claims that I've been mentioning?
I'm going to repeat for the fourth time that it depends. But we see from the cases that the usual methods to identify the perpetrators is to seek a Norwich Pharmacal order. You can see as an example the Stokoe case related to a cyber attack and theft of information. Or as Dean will discuss later, you have the Bunker's trust orders that are more appropriate perhaps for parties that are outside their jurisdiction. And what the Norwich Pharmacal order does is request the third parties involved in the wrongdoing, i.e. the crypto exchanges, to disclose, or investigator or whoever the third party may be who were involved in the wrongdoing, to disclose documents and information in sworn affidavits to enable the claimant to identify the ultimate wrongdoer and plead a case against the wrongdoer concerning the cyber attacks. or the cryptocurrency fraud, the applicant, the claimant, needs to show that there is arguably been a wrongdoing, and that the real prospect that the respondent is mixed up with, facilitated, or is involved in the wrongdoing, and the respondent has relevant information which can be the subject of an order. There is no need for the applicant to have a definitive intention to bring an action against the respondent, against the cryptocurrency exchange, for instance. There is no need to prove a proprietary claim against the ultimate wrongdoer at the start. And an example of that is the Stokoe case. But the exchange cannot be a mere witness of the rule, a mere witness of the wrongdoing. He has to be involved in facilitating the wrongdoing. So without the actions or the participation of the third party, the exchange, the wrongdoing could not have taken place. But I think you have another question for me, Mark.
I do, and this is a slightly more niche procedural point, but what is the mechanism for obtaining information from third parties via disclosure affidavits? And probably even more niche, if the affidavit that you obtain is unsatisfactory, in what circumstances will the courts order cross-examination of that individual who has sworn the affidavit?
As I said, the initial affidavit is sworn pursuant to an application for a Norwich Pharmacal order, in which the respondent will have to answer the questions that are put to him about where the identity of the perpetrator and what information he may have or she may have about the perpetrator. But there is a recent Court of Appeal decision in the case of Stokoe Partnership Solicitors and Grayson of 2021, very recent of this month. If you are interested, we have a YouTube video summarizing the case in our YouTube channel. I don't have time to give you all the facts, but the High Court initially denied the claimant's applications to cross-examine the two defendants in relation to affidavits sworn pursuant to a Norwich Pharmacal order, and the claimant thereafter sought to appeal that decision in relation to one of the defendants, who was a private investigator and allegedly involved in the cyber attacks. And the Court of Appeal upheld the decision of the High Court and confirmed that even if there are serious allegations against the defendant, the courts will not generally permit the cross-examination of a defendant where there are ongoing proceedings against the defendant prior to trial, where the matters for cross-examination overlap with the issues in the substantive ongoing proceedings. Crucially here, the Court of Appeal noted that the defendant was not an innocent third party, since he was a defendant to a claim against him seeking damages or other relief for conspiracy with others to injure the claimant. There's another case that I will just mention briefly to you, which is the Kolomoisky case, where more or less the same was decided in relation to a freezing or preservation of assets order, where the order for cross-examination was not granted. So it is a very high threshold. But Carrie, you will deal with the next issue, won't you?
I will. I've got a question actually for Dean that goes back to something we were discussing earlier about how when cryptocurrencies reach an exchange and they can't be traced any further. We've heard about Norwich Pharmacal orders from Celso, and there's authority that suggests that they are limited to being granted within the jurisdiction of England and Wales. But with so many exchanges overseas and decentralized, etc., what disclosure orders can be sought against exchanges outside the jurisdiction in order to try and identify perpetrators or trace assets?
Well, first of all, bankers' trust orders can be, and there's a digest. In the digest, you'll read a little bit about a case called Robertson, which is an unreported case, but one of the very first cases actually that certainly I came across where crypto assets or cryptocurrency in this particular case was described as property. In that case, the court made bankers' trust orders enabling Coinbase to disclose information relating to the account holder. The second and very significant example I can give you, again in the digest, so please don't need to write all this detail down, is the Iron Science case. We've mentioned it several times, can't stress enough how important it is. Major developments in that case. Again, a bankers' trust order was made which had satisfied the following test: whether it has been shown that there are good grounds for concluding that the property, and I reiterate the fact that here the property is crypto asset, in respect to which disclosure is being sought, belongs to the claimant, that there is a real prospect that the information sought will lead to the location or preservation of those assets, that the order should not be wider than necessary, that the interests of the applicant in getting an order have to be balanced against any detriment to the respondent, and the applicant should provide undertakings only to use the documents for the purposes specified and pay the respondent's expenses of compliance if the order is wrongly made. The court found in Ion that the that test was satisfied. A note also in Robertson, which was a UK exchange, and Ion was an overseas exchange, that also ancillary disclosure orders were made both against the exchanges and the perpetrators themselves. In the other very important case of AA and persons unknown, again, will be in your digest, so therefore please don't worry about writing this down. There sought and granted were proprietary injunction, a worldwide freezing order, and an ancillary disclosure order against the fraudsters who were persons unknown. The court recognized there the importance of the privacy of these matters in order to stop, it was a phishing attack, in order to stop further copycat type events. Again, very significant. So Kerry, I think you're going to ask me something else now, which I'm very happy to deal with.
Yes, I am. I'm going to ask this question. I'm conscious of time, so once we've dealt with this question, I think we'll move on to some more questions that Mark has. But this one, it's drawing on the cases that you've mentioned, Dean. So AA and Ion, they have very different approaches. In AA, there was a substantive claim of restitution and or constructive trustee against the exchanges, and a proprietary injunction and ancillary relief of providing information. Compare that with Robertson and Ion, where there was a banker's trust order against exchanges and no substantive claim against the exchanges. Which is the correct approach, or which is the most beneficial approach?
Well, the issue here, I think, is in AA was that the basis upon which it was put, part of the judgment, was that in order for a constructive trust to be found, which the court did, that involves unconscionable conduct of the legal owner of the property. Now, it was difficult. It's difficult for me to see what unconscionable conduct on the part of the exchanges that they could have seen, if that's what the court was talking about. And are the exchanges in that particular situation the legal owners? For me, the better approach is Ion. We've gone through the circumstances of Ion. It is much neater and tidier than the constructive trust approach that AA Limited sought. So again, please look at your digests. In the interest of time, I'm going to make the comment that my preferred approach is the Ion approach as opposed to the AA approach.
Okay, thank you, Dean. I've seen that we have one particular question which has popped up in relation to jurisdictions, so perhaps I'm going to take us more in that direction with another couple of questions. So everything that we've talked about so far presupposes that the courts of England and Wales have jurisdiction over the substantive matter. However, given the international features of crypto assets and also fraud, that's not always the case. For example, terms and conditions, terms of use, etc., may have exclusive jurisdiction clauses in favour of a particular and potentially less favourable or less claimant-friendly jurisdiction. So my first question, which I'm going to throw back at you, Dean, if the entire operation within a particular scenario is fraudulent, i.e. fraudulent companies set up, etc., assuming that those clauses would be struck down due to illegality, and so assuming jurisdiction could be established, can you bring proceedings in the courts of England and Wales under those circumstances?
Yes, well, I say yes proudly, not having yet argued in front of the court, which will be fairly imminently happening to me. So you can all laugh when it goes the other way. But no, I'm very strongly of the view that if the whole operation and the whole set of circumstances is fraudulent, then that clause would be void for illegality and that part of the contract. So I don't think there's any issue with that.
that being the case, that probably isn't so much a controversial question, but what is the situation, would you say, if the entire operation wasn't fraudulent? Would an exclusive jurisdiction clause still stand in those circumstances?
Very difficult to give a definite view about that. There are some avenues, and we in the team have discussed how this may happen, because there is often the case, and I certainly came across one relatively recently, where what looked like a perfectly proper contract had, for example, an exclusive jurisdiction clause, which was clearly designed to frustrate those who wanted to pursue actions in what I would call mature jurisdictions, including this one. So that's a more tricky one. One of the ways that we have in this team considered a possible way of looking at this is whether the consumer protection legislation bites here. I will just mention the Act, which will be in our digest, and then it will be for you to think about in terms of whether you feel your particular case that you're seeking advice on comes within these parameters. But the Consumer Rights Act 2015, which repealed and replaced the Unfair Contract Terms Act and the Unfair Terms and Consumer Contract Regulations, explores the relationship and gives protection where there are consumers and traders. Now, again, that is distinctly possible, that it's possible to get yourself within those particular definitions. If you do, then you could argue that that's the legislation that's likely to govern one of those particular clauses. What I will say is that the courts have shown an appetite, if I can use that expression, where people are deliberately trying to take this away from a mature jurisdiction, particularly if everything else is happening in that particular jurisdiction, and in this particular case, the UK. The courts will do their best to say, well, actually, clearly, this is what was intended here, and it was a particular device to make sure that it wasn't heard in whatever other jurisdiction it might have been, which doesn't have the same safeguards and protections, and candidly, the same developed case of law that we've got in the UK on crypto assets.
Thanks, Dean. If I can take that point just a little bit further. So if you have a dispute resolution clause in favor of a foreign jurisdiction and it is likely to be valid and binding, that jurisdiction may, of course, not have the same interim relief options available as we do in England and Wales, and nor may that jurisdiction particularly view or conceive of crypto assets in the same way as the UK does. So my question, it's probably my last question on jurisdiction. Is there anything that the courts of England and Wales, is there anything that the courts can do here to assist in the tracing or securing of assets prior to substantive proceedings?
Well, the answer is yes, and I'm also going to pick up on a question that we've got from one of our panelists, and I'll read it out because they're always very useful to share with everybody. I work in a US financial institution, and I'm not aware of any US court granting a worldwide injunction. Would a UK court entertain a US plaintiff seeking relief, given that the blockchain is accessible worldwide? I do not think a US court would find it has jurisdiction to hear the case. One of the things, and thank you for that question, one of the things that I've used and is a fabulous, I think it's fabulous, little piece of legislation which helps in these areas, and again, it will be in the digest, but I will read it out, is Section 25 of the Civil Jurisdiction Judgments Act 1982. And what that does is, and I'll just take 2 minutes to tell you what it does, and I have used it, I can say, it permits interim relief to be sought in England and Wales in respect to proceedings that will ultimately be governed by the law of a foreign jurisdiction. There are some safeguards. It must not be inexpedient to grant the relief sought, and the relief sought can't be inconsistent with the law of the jurisdiction where the substantive proceedings are taking place. But it's important that it's distinctly possible in those situations to say, I am starting, and it applies to interim relief, I am commencing proceedings in the UK. I am giving effectively undertaking that I will switch to the most suitable jurisdiction, America perhaps in this case, after when I move further into final relief. But that's rather interesting and rather useful. And as far as I am concerned, it's very significant in the sense that it provides a protective wrapper around the crypto assets until substantive proceedings can commence. So don't lose sight of that one. It's a very useful provision, as I say, that will be in your digest. Well, not bad in terms of timing today. It is 10 to 5, or 8 minutes to 5. It's now my job to act as the MC to just pick up a couple of questions. I've already sought to answer one, which I hope was of use. I'm going to throw this one, and someone can put their hand up for this one. It should not be a problem establishing standing before a court to take personal data down from a website where the data is a customer data, because the party making the application will be the controller in Data Protection Act terms of that personal data. It has sufficient interest and obligations to pursue that remedy. Why do you think it's potentially a problem in terms of standing? I think that was probably a question aimed at blocking injunctions for websites. So who would like to put their hand up? I can see them.
I'll take that one, Dean,
Yeah,
since that's my point. Yeah. I don't necessarily think it will be a problem eventually, but the way that website blocking injunctions have developed is through copyright and trademark infringement, where it is very clearly the infringement of a particular person's rights, and that is the person who is bringing the application. In terms of a company where it is customer or client data, you're absolutely correct, there would be a data controller. I would view being a data controller as more imposing an obligation on the individual rather than giving them rights. It is the data subject that has the rights in that data rather than the data controller. And so purely looking at it as which is the easier route, the data subject would be able to bring the claim. I think it is entirely arguable that the data controller would be able to bring that claim. And that is potentially the way the courts are going to develop it, and indeed probably how they will develop it to try and combat this particular problem. But in terms of the actual test for a website blocking injunction, on the face of it, it poses just a slight issue.
Yes, I agree. Can I ask another question? To what extent can you bring a claim against the exchange from which you have traded your cryptocurrency? Is the best you can do to apply for a knowledge pharmacal order against the exchange? Lots of parties, including casual traders, would rather bring claims directly against the exchange rather than trying to trace the funds or find the real perpetrator. Kerry, or Celso or Mark?
Oh, I think everybody was going to answer that one. It's quite an interesting question. My initial thoughts before the others comment is that I think that it's where the law will develop in the next years, because yes, you can if the exchange is in the UK, you probably can go for a knowledge pharmacal order. If the exchange is outside the UK, it's more likely that you're going to have to go for a banker's trust order. There is that conflict between the ION decision, the science decision, and the AA decision as to whether you need an independent cause of action or not. I think that it is probably, I agree that it's probably right that you do not need an independent cause of action against the exchange, but then you are going to be left with a problem. If you cannot identify the persons unknown, but the asset, the crypto asset has been frozen, how do you then take that out of the exchange and get the exchange to give it to you, assuming it is an innocent exchange? So there will have to then be a cause of action for that. But I think that to obtain the knowledge pharmacal order and banker's trust order, there should not be the need for a cause of action. I don't know what the others think.
Anybody else want to jump in on that?
I'll just jump in very quickly. I think it's potentially quite difficult unless the exchange is implicated in some way. They're effectively, for want of a better phrase, they're equivalent to the bank in a typical fiat fraud, and they are effectively holding an account and they have no interaction with it. Depending on the jurisdiction they're in, there could be regulatory issues if they haven't done their KYC that they need to do or complied with AML measures, and therefore they don't have the information that they are required to have in relation to that account holder. again, it sort of comes down to circumstances in the jurisdiction. But I think actually bringing a claim against the exchange at the moment, especially since Ion Science is potentially the better approach than AA, where there was a constructive trustee and restitutionary substantive claim where there wasn't in Ion Science, I think it's going to be difficult. It's an area to watch and an area that will develop. I
agree, and as I say, and if I can be optimistic about that, I totally agree with the practical issues that both Celso and Kerry have pointed out. The good news is that what I certainly see, and what has been seen in all the reported cases, is that courts aren't treating crypto assets as if they're something to be mistrusted. They're also not treating them as if they're something which are completely alien. They are using usual and well-known principles and doctrines to assist where they can. And the AA case, for what else it might have been, was a genuine attempt by the courts to try and accommodate and to try and deal with a situation which was not of the making of the loser. And so I wholeheartedly agree with Kerry's last sentiment, is that yes, there will be issues, but the courts have seen fit. As I say, I reiterate the point that the judge in AA Limited, for example, heard the application in private because he was very conscious of the fact of the ramifications of hearing it in public. There's a really good example of the UK courts giving effect to try and make sure that they are being as helpful as possible and as progressive as possible when dealing with these new developments that aren't always straightforward to them. So I don't always agree with everything the judges say, by the way, but I do commend particularly the judge in that particular case. Now, there's a question, and I'm very envious, from Barbados. How is crypto asset global freeze defined? For Bitcoin, does it refer to specific Bitcoin transactions and recursively apply to all future traced transactions from those transactions? What about additional privacy measures such as coin joins that increase the anonymity set? Anyone want to put their hands up to answer crypto asset global freeze definitions? There's a deafening silence. So
yes, I would just say that you know there is a lot of leeway when you are discussing how to draft a freezing order or a proprietary order. You see that in some of the cases discussing some amendments to the order, when the judges are handing down their judgment. I think that what I have seen is that the freezing order normally refers to the wallet and all the Bitcoins that are in that wallet. There is nothing to stop you from asking that it's a broader type of order, but it will say all future traded transactions are forbidden in relation to their wallet.
Yeah, and so I totally agree, and it's coming back to the point that we've all made, and certainly I'd like to stress. Let's not treat crypto assets as if they're something from Mars. Let's make sure that in any way you would have the drafting an order, and that would be your responsibility, or you would be dealing with it. But assume it's your responsibility, you would draft the order to make sure that the objective is met. Celso was absolutely right that Bitcoin, for example, as mentioned in this question, would be referable to the wallet. And the privacy measures that are mentioned here are less significant than identification of the property. Let's not. Yes, there were elements, and I have spoken about the privacy issues, but let's not detract that away from what is being sought. It is relief in respect of the property that we're concerned with here, not the anonymity relating to that property. So the answer to the question is, it's likely to be defined, and it would be the practitioner's responsibility to do it properly. Let's be candid. It's likely to be defined as referable to the wallet, because that's what it would be. And as Celso rightly says, it would also be defined so as any future transactions would not defeat the order in the normal course of events, exactly as everyone would always do in the usual course of events. So I hope that's helpful. And I hope that as we end, and I've just got a couple more things to say, but as we end, I hope that it is of significance, because it brings back the things, the key concept, which I always like to stress, which is please don't treat crypto assets as if they are, as I say, something from Mars. That the courts are doing their level best. We, as practitioners in this team, are doing our level best to make sure that people understand that there are special considerations that are required. You've got to know what you're talking about, as with all things. But it is important that you move through the jargon and you see what exactly the relief you're seeking is, and you draft accordingly. So can I, with that, thank everyone very much, first of all, for their attention. Second of all, for the questions. Usually at this stage, I announce when the next webinar in the 36 commercial series is going to be. All I can tell you, and keep you guessing, it's going to be in June, and it's going to be, the title is going to be determined. We will tell you through the usual social media channels, those of us who know, who follow 36 commercial, and each of us on this webinar will know that we're all active on LinkedIn and Twitter. Please follow us and please see what we're up to. 36 commercial also has obviously the website and Spotify. There's also a YouTube channel which has all of these webinars in our cyber law series. So once again, thank you very much for your time and attention. Please watch out for the next one of these, which I say will be in June, and you'll be the first to know when we reveal the title. So good afternoon to you all, and thank you very much.